It seems like every day there are new details from the Twitter Whistleblower report that gives Musk more and more astonishing details about the company. For example, Peter Mudge Zatko, Twitter's former security chief, accused the business of concealing a series of dangerous activity, including knowingly conceal exact data about spam and fake accounts from the public. With that, since the judge allowed more access for Elon's team to analyze the platform, lawyers found astonishing inside details about Twitter that was willingly kept secret from the public. As a result, this process is turning out to be the biggest scandal of this century. Moreover, Musk's team finally revealed their genius plan about how they will finally win this case. This is a very interesting story, so let's explain it. Many individuals have previously characterized Musk's case as very weak, with the exception that Musk may have undisclosed, devastating proof. He now possesses a more visibly lethal weapon. Zatko isn't some troublemaker, he's a well-known white hat hacker. While Twitter termed the report a bogus narrative, replete with errors and falsehoods, the majority of Mudge's allegations appear completely believable. Zatko notified the Securities and Exchange Commission, the Federal Trade Commission, and the Department of Justice of his findings. A redacted version was sent to Congress, which was subsequently leaked to the Washington Post and CNN. Twitter might face a variety of legal consequences. Lawmakers acknowledged they are looking into Zatko's allegations, and the report alleges Twitter breached a consent agreement it agreed to in a 2010 FTC deal, so it might face fines or more charges from the agency. However, unless something extraordinary occurs, the FTC penalties are likely to serve more as a minor annoyance than an existential danger. The Twitter versus Musk trial, which begins in October, is a very different story, and Zatko begins with a point that is very relevant to Musk. He claims that Twitter's leadership misled regarding how many Twitter users were bots as part of a series of fraudulent or misleading disclosures to authorities, the world, and Musk himself. Contrary to the CEO's tweets to Musk, he writes in the report that Agrawal knows full well that Twitter executives are not motivated to correctly identify or report complete spam bots on the site. Among the executive leadership team, willful ignorance was the norm. Zatko has denied disclosing details to anyone who has a significant stake in Twitter, and while there has been some baseless speculation that he is working with Musk, it sounds overly convoluted. If a dissatisfied ex-employee has a grievance with Twitter, a trial like Musk's is just an amazing chance to expose it. Zatko's assertions are most likely the best proof Musk has right now. The conditions of the Twitter arrangement make it difficult to pull out based only on newly acquired knowledge regarding things like bots. However, Zatko's analysis does highlight a number of precisely unknown hazards and errors. Musk might claim that Twitter neglected to disclose severe operational issues in disclosures, like as its SEC filings, and that he consented to the acquisition based on such reports. That would enhance his claims that Twitter withheld damaging information that should have sunk the merger. It's also worth mentioning that we've primarily heard Zatko's version of the story thus far. As previously stated, many of the report's findings are believable, but many details have been redacted. All of it gives Musk greater influence ahead of the trial. If his objective is to lower Twitter's price, for example, he is in a stronger position to achieve it. In the long run, though, analysts appear to be upgrading the billionaire's case from poor to dicey. What is Elon Musk's or his lawyer's plans and moves to finally win this case? As per filings in a Delaware court, Musk is requesting records from advertising technology companies in his attempt to learn more about bot and spam accounts on Twitter. Musk's attorneys have sent subpoenas to both Integral Ad Science, IAS, and Double Verify for any records or correspondence pertaining to their role in examining accounts or involvement in any examination of Twitter's user base. Both IAS and Double Verify, located in New York, employ technology to properly identify that digital advertisements are being viewed by real individuals. Advertisers employ the services to make sure that their paid advertisements are viewed by potential consumers, rather than automated bots. Twitter was also ordered to provide Elon Musk with more data about spam and bot accounts as part of his court battle to force the billionaire to complete his $44 billion takeover of the social media site. Judge Kathleen St. J. McCormack of Delaware Chancery Court ordered that Twitter must turn up information regarding 9,000 accounts it assessed last year, with the aim of determining which had human beings linked to them. On security and other grounds, Twitter attempted to refuse Musk access to this historical snapshot. McCormack said that Twitter must also disclose documentation demonstrating how the 9,000 accounts were chosen for review. Anything new? New developments that have happened recently about this case. Twitter co-founder Jack Dorsey was served with a subpoena. Mark Andreessen, a well-known venture capitalist, was served too. Oracle's chairman Larry Ellison and financiers David Sachs and Joe Lonsdale also got them. So far, Twitter and Mr. Musk's lawyers have issued more than 100 subpoenas, trying to target large banks, Goldman Sachs, Morgan Stanley, high-profile shareholders, Andreessen, Howitz, Sequoia, well-known consultants, influential businesses that employ Twitter's board members, Salesforce, MasterCard, and members of Mr. Musk's inner circle. So far, Twitter has been the more active player in the discovery process. The business has filed more than 84 subpoenas in an attempt to unearth communications that might show Mr. Musk was dissatisfied with the acquisition since the economic recession reduced his personal fortune. Subpoenas have been sent to Mr. Musk's acquaintances and allies, including former SpaceX board member Antonio Gracias and entertainment executive Christina Salon, in order to get access to their group conversations. The business has also invited investors such as Mr. Andreessen and Mr. Ellison, who had promised to provide funds so that Mr. Musk could complete the transaction. Mr. Musk's side has sent more than 36 subpoenas, including one to Mr. Dorsey, in an attempt to prove that Twitter misled about the volume of fraudulent accounts on its site, which he has claimed as a cause for pulling out of the transaction. Peter Zatko, a former Twitter executive known as Mudge, who has accused the business of making misleading assertions about its security measures, was subpoenaed by his attorneys. Elon Musk's attorneys stated that the latest whistleblower report by Peter Zatko, Twitter's former security head, presented more grounds for Musk to step back from his deal to purchase Twitter for $44 billion and sought a stay of proceedings while the charges were reviewed. The petitions, which were disclosed in regulatory and legal filings, are an attempt by the billionaire to include Zatko's charges in the upcoming trial, which will decide whether Mr. Musk is obligated to complete the purchase. Musk requested that the trial be postponed for 1 month while his attorneys investigate the whistleblower accusations. Zatko has accused Twitter of material omissions and inconsistencies concerning the security and privacy safeguards built into its platform for years. Twitter officials have flatly denied Zatko's allegations. Twitter attorneys responded to Musk in a letter that was also released in a regulatory filing, saying that Zatko's statements are replete with contradictions and falsehoods and lack critical context. Both Musk's previous and current attempts to leave the transaction were deemed invalid and unlawful, and Twitter stated that it will continue to push Musk to purchase the firm at the agreed cost. Although Mr. Musk and Mr. Zatko have both accused Twitter of deception, their charges are not the same, making it impossible for Mr. Musk to incorporate Mr. Zatko's assertions without resorting to legal maneuvering. Mr. Musk's attorneys appear to have laid the framework for such a lawsuit. They have raised Mr. Zatko's claims during a briefing in Delaware and revealed in a court filing that they had subpoenaed him. What other experts are thinking about this situation? Spat, a finance professor at Carnegie Mellon University's Tepper School of Business and former SEC chief economist, said that his first thought was that Musk negotiated this contract that rendered due diligence unnecessary. But he now believes there's a lot more to the story, because he believes Musk may fairly argue that he relied on the company's representations. And the whistleblower is throwing into doubt not just some of his conversations with senior officials, but also, at least implicitly, the company's disclosures. Ann Lipton, a law professor at Tulane University, shares this viewpoint. Lipton is skeptical of Zatko's particular assertions concerning bots because even Zatko isn't labeling them outright frauds. He's basically saying that Twitter calculates its user statistics in a self-serving, deceptive manner. However, she acknowledges that the transparency issue is a slight problem, despite the fact that it mostly includes objections Musk never made, but would almost certainly now contribute to the case. She believes his comments about the bots benefits Twitter, since he concedes the marketable daily active user counts are correct, but he believes Twitter should use different measures. However, his other charges concerning different internal issues may be a dilemma for Twitter. If they are severe enough to substantially jeopardize the company's long-term economic well-being, they may constitute a material adverse effect that breaches the agreement and allows Musk to walk away. Unfortunately for Musk, it is still impossible to break these agreements by design. As Spat pointed out, Musk raised the bar by foregoing proper research that may have revealed operational concerns at Twitter. In recent times, courts have compelled mergers, even when substantial financial concerns have been identified, such as in a 2001 case when Tyson Foods was ordered to buy its rival IBP. According to Yer Listikin, a Yale Law School professor, the claims are serious and somewhat help Musk's case. However, he finds a striking parallel to the IBP case. He stated that the contract is drafted in such a way that this sort of argument is unlikely to prevail. That's it for today. Subscribe to our channel for more Elon Musk content. Bye!